Welcome back to Coin Lady channel, where you can watch about the latest and most interesting developments in the world of XRP. Ethereum's persistently held status as a non-security has to be the most peculiar aspect of the current legal framework around cryptocurrencies. Tokens of the XRP cryptocurrency, however, could be. For the purpose of this video, I have some new evidence that disproves that assertion and will provide it to you. Also, unlike Ethereum, XRP is not classified as a security. If there's time, I'd also like to share my thoughts on whether or not the Supreme Court will accept the current Ripple SEC case. There has been a lot of speculation recently regarding what would take place once the case we are currently following concluded. Does this involve the highest court in the land? The XRP price chart and my analysis of it will be presented in the video's final minutes. Provide an explanation for what will trigger our breakaway from the current limiting range. Let's hope you can stick around for that. Trust me, you won't want to miss it. In this video's opening minutes, I'd like to talk about a profound observation made by Stephen Hubert. And the question of what does and does not count as security is at the heart of the debate. However, as many of you are aware, this is a very confusing problem in the Bitcoin industry, and the SEC is largely to blame. During Jay Clayton's tenure at the SEC, the agency came out and declared that all ICOs were in fact securities. To be honest, I found myself agreeing with this and thinking it made a lot of sense. It was expected that you would seek funding from investors before the launch of your token. In addition, initial coin offerings are frequently compared to securities. I saw no flaw in this line of thinking and agreed with it. When the SEC suddenly ruled that XRP, a coin without an ICO, was a security, it complicated matters. Now that the SEC's logic directly conflicts with the agency's own one regulation and single piece of market transparency, it's easy to see why the agency is having such a hard time maintaining its position. The market's lack of transparency since then has rendered the SEC's sole assertion obsolete. An intriguing point is made by Stephen Hubert in this article on how XRP was never a security, even in its early phases, and he calls attention to the fact that XRP actually traded without a price when it was first released. The service was provided at no cost for almost a year. This is quite important because one of the most crucial aspects of any investment agreement is whether or not the investor intends to make a profit. XRP has been without a price for over a year, and I'm just now learning about this. I knew it had been without a price for some time, but I didn't realize how long that time had been. However, even in its infancy, that boundary makes any investment contract changes impossible. This illustrates, if rather confusingly, that XRP is ultimately just software with a value attached. As far as I'm concerned, it nails the idea that the secondary market for tokens is the only place where it matters at all. The token itself cannot serve as a guarantee of safety. It doesn't make sense, and we've discussed why that is at length. Currently, the only real unknown is the initial sale process for the token. Now we know that for over a year, XRP traded without any value at all. As a result, XRP was never provided as a security, not even at its inception. As opposed to something like Ethereum, which had worth even before it was invented. The Securities and Exchange Commission has publicly said that this is a fair definition of a security. At now, I don't think Ethereum is safe to use. Although it was never really advertised as such, there are still some who believe it. As far as I'm concerned, Ethereum isn't a security. To increase their authority, the SEC would rather have all financial instruments classified as securities. Thus, they avoid admitting this reality. Yet, this merely shows how absurd the SEC's claims have always been and how they have never been backed up by evidence. Discovering new information that hasn't appeared in the Ripple SEC case fascinates me and further proves the SEC has been completely wrong the whole time. As this is the case, the XRP community will be the first in the cryptocurrency industry to finally get the answers it has been seeking for years. I hope that the judgment in the Ripple SEC case will help all projects realize that the token's ICO is the security, not the token itself. Yet, the resolution of this litigation is necessary before we can know where that matter goes. So I'd like to say a few words about the recent Voyager Binance SEC issue. I'd rather not dwell too deeply on the topic, but there is something fascinating that needs to be made crystal apparent. Everything on the market right now is a security, as Gary Gensler has made clear. Because he's been a part of the SEC, all you have to do is look at these rules from the 1930s to realize that they are as clear as day. In the Voyager of SEC case, the judge made it quite plain that the SEC has no jurisdiction over the issues at hand. He's telling the SEC that the idea that anything may be considered a security is completely false because the SEC has not provided any such clarity. Even though Bill Hughes added his own interpretation of what the judge and SEC were saying, I'm not going to trillionaire the original court document. I'll just read it out loud to you. You're being ambiguous, Judge. We will convey our thoughts to you in confidence, Judge. Make it known to the world. SEC, fine. Members of staff consider the Voyager token to be. Binance US is a registered exchange under the Securities Exchange Act of 1934. However, the Commission has made no official announcement to this effect. Don't go through with financing buying Voyager. The judge gave a definitive negative ruling. There seems to be a lot of ambiguity here. In this instance, the judge specifically rebuts the SEC's position that it may arbitrarily set rules in any situation and declare that anything is under its jurisdiction, even though it hasn't disclosed that to the public. This is really important since it may be used in the Ripple SEC lawsuit. A judge has now ruled in court that Bitcoin supporters are correct in their assertion that the SEC has not provided any clear guidance to any sector of this market. This directly contradicts what Gary Jensen has said, and it highlights how unsettled the current situation is. The SEC's prosecution of Ripple, which was handled in extreme haste, will backfire spectacularly. The SEC's actions here go beyond mere illegality. However, they didn't advise Ripple that the SEC saw XRP as a security, which is something they should have done. Because of this, their case was doomed from the start. The SEC's case is considerably weaker than they had anticipated, and after contacting with other attorneys, I've realized that they all agree with me. I'd like to talk about whether or not I think the Supreme Court will hear this case now. This is something that many people are considering, so I understand that it is a complicated issue. Let me then summarize the situation by focusing on two main points. Sincerely, I think Ripple filed a petition with the Supreme Court. They have nothing to lose if they lose this lawsuit and get a horrible decision, which I don't think is going to happen. In all likelihood, they would file a petition with the Supreme Court. Here, I'd want to offer a more convincing argument that, in my opinion, contradicts the conventional wisdom. So that you understand why I don't think the SEC will take this case to the Supreme Court, let me explain. I've already indicated that many legal experts think the SEC's case is far weaker than expected. But the SEC did not release much of the evidence that could have helped their case. Other points have been raised by the XRP community that I won't go into here, but which, if considered, could have given the SEC a stronger case. Even legal professionals were taken aback by this. This is some of the data the SEC released. According to recent information from John Deaton, the SEC is planning on filing between 200 and 300 more charges involving cryptocurrencies. The SEC is losing badly to Ripple, people. After spending so much time and money on the Ripple case, the SEC really needs to win some cryptocurrency. They shouldn't prolong this any longer than they already have to. In addition, we have already covered how the SEC's loss in this case could serve as an industry standard. That would be 10 times worse for the SEC if they lost in the Supreme Court. A big setback for the SEC that would definitely serve as guidance to the whole industry. I don't think the SEC will take that chance. They're prepared to move beyond the Ripple case, thus they are preparing anything from 200 to 300 other cryptocurrency scenarios. Unfortunately, not well at all. The final point is that Gary Gensler did not create this particular instance of Ripple. This item was originally Jay Clayton's. Gary Gensler may be a passive observer who is eager to get out of this situation. Despite his many faults, Gary Gensler is not an idiot, and I am confident that he is well aware of the SEC's case's dismal prospects. What I don't understand is why Gary Jensen is dragging this out for so long. The XRP community's discontent with the SEC's actions has been heard and understood by all. The SEC should not be putting itself in this precarious position. Art criticism wouldn't be a problem if the SEC were doing well. Artistic criticism wouldn't matter much if Ripple was engaged in unscrupulous practices behind the scenes. Finally, the SEC filed suit against one of the most transparent companies in the Bitcoin industry, which has always done its best to comply with the law. The SEC's approach is obviously failing, and I don't expect them to go to the Supreme Court to fix it. If the SEC is actually simply interested in punishing Ripple and trying to injure them as much as possible, perhaps out of spite, then they could always appeal to the Supreme Court, which is the only warning I will make. Yet, I do not believe that the SEC will be brave enough to take such a chance. Last but not least, I'll briefly go over the XRP price chart to round off this video. Just crazy. The XRP exchange rate is still quite volatile. The clocks in this area are really convenient. They prove how long XRP has been consolidating. We're staying put in this area. Nothing significant has occurred as of yet. But then I saw the XRP captain tweet a funny picture of this very chart, right before Judge Torres issued his ruling. Sincerely, I think this will be the catalyst that finally breaks us out of this trading range. Naturally, at this point, we have no idea when this decision will be made. I was hoping we'd have settled on something by now. According to my research, many lawyers who specialize in this area of law think that this decision would have been made by now. But if the issue with XRP is clarified by Judge Torres, which I expect will happen as a result of this action, it will pave the road for every regulated, traditional financial institution to enter the market with confidence and the assurance that they are not infringing any securities laws. In addition, no other cryptocurrency will serve as a comparable catalyst for XRP. So, gentlemen, thank you so much for coming here today. Thank you for watching, and I hope you found this update interesting. If you did, please let us know by clicking the like and subscribe buttons. See you later, bye.